Good evening. Good evening, everyone. Welcome once again to Legal Hour with Connaughts. It's Shirya is with us today. Welcome, Shirya, again.
Same faces.
Same faces.
Hopefully with some new and helpful information for everyone.
Definitely. We apologize for not coming very regularly in the past few weeks. Unfortunately, it was a very busy month for all of us. But there is a lot of update when it comes to human rights claims, some other issues we want to discuss today. There were some new case laws as well, which we will update you on. And of course, we have a new Prime Minister, so there's a lot of rumors around in the air that there may be some new amnesty coming up. So we'll discuss that as well for you. Shirya, let's start with the recent case of Court of Appeal, Mamun Ahmed versus Secretary of State regarding 10 years long residence.
Well, yes, 10 years we'll be discussing in two ways today. One is the case of Ahmed, which came early this year. I know we've talked about this before, but we continue to get a lot of questions from people, so we want to just do a specific program talking about the 10-year law. One thing which I wanted to just say at the outset is that there's confusion. People believe that if there's any time spent in the UK in the 10 years as a family member of an EA national, that time doesn't count. Or for some reason people come up with questions that student doesn't count or X or Y does not count. It's incorrect. The law is simple, that as long as you've lived in the UK continuously for 10 years, then your residence has been lawful and you are eligible to make this application. So that's one thing you should set straight. Of course, get specific advice if you've been in the UK, let's say as a member of family member of ambassador or someone like that, then you're exempt from immigration control. That's a separate theory, but all said and done, it isn't the case that if you're here as a family member of an EA national that you won't be eligible. Beyond that, what the case of Ahmed has sort of finalized, which is a question a lot of lawyers and judges and everyone was grappling with, was that whether if you made an application within 14 or 28 days after your last leave expired, whether it was an appeal or it was a visa, and that application was consequently in due course successful, and or if you've made an application and not completed 10 years, let's say you're on 9 years, 8 months, 9 years, 10 months, and then you make an application within the permitted 14 days, which the Home Office says it will disregard, then what should happen? And what this case decides is that you need conclusively proper full 10 years lawfully, and if you made an application within the grace period of 14 or 28 days, then that will not extend your 3C, and that would mean that you would have not accrued the necessary period for a lawful residence. Now, it was a disappointing decision, and that this was a position that the Home Office has been taking for quite some time, but there wasn't case law on it. So what we would find is that if there was a right of appeal, then it's a question of each judge at the first tier tribunal as to how they would determine it. Judicial reviews were more difficult, and it looked like the upper tribunal would agree that in law there should be no right of appeal, and further that person is not completed 10 years. But with respect to the decision of Ahmed, we do believe that that case had its specific facts, that it was argued under certain conditions at a certain point, and that it's not the final word on the case, on the point whether you've completed 10 years lawfully or not. That should be the only reference point. And therefore, we're advising people that if you have cases where there are problems in your 10 years, specifically if you made applications early but then still completed 10 years, or if there are gaps with it which are less than 14 or 28 days, then come and see us, because we're kind of mounting a legal challenge now, just as we did with the big TOEIC cases or other cases that we've challenged. That one big case we've got in the Supreme Court now, challenging EA regulations. It's never final with respect to the courts. Again, of course, what one judge at the upper tribunal or the Court of Appeal would say, because if you disagree, this country allows us to challenge it further. And it's always better when we combine the number of cases and we get senior barristers, QCs involved in the case. A lot of minds get together and we find a solution. So what we're effectively then saying is that if you've got these 10-year cases, get in touch. We're doing something together, and we want more and more cases so we can see what are the specific facts on each case and how we could challenge it.
Excellent.
So I think that's final. I believe you've got a couple of cases as well where
in Court of Appeal, yes,
Yeah.
challenging the exact legal point
Yes,
which
yes.
was discussed in Mahmoud Ahmed.
exactly.
Just to clarify, Sharia, a lot of people still have confusion as to how to accumulate 10 years long residence under 276B. A lot of people think that as long as they have put in an application within 14 days after their leave is expired, and that application continues, they vary that application several times and they finish 10 years whilst their application is pending, they have legally finished their 10 years lawful residence. Now this is the position us practitioners generally would take if the decision comes in after 10 years are accumulated altogether.
Yes.
Even though we do not dispute that the applicant does not have 3C leave remaining, that is not something that is in dispute because
That's a point of law,
it's a point of law which is
Yeah.
very clear. What this decision states is that any time you have spent without legal leave in the UK, so for example, if your leave expired or your appeal rights were exhausted when you accumulated 9 years 6 months, for example, and then you put in an application within 14 days and that application lasted for 6 months, and whilst decision was being made you finish your 10 years, this decision specifically states that that means you have not accumulated 10 years lawful residence because you have not met the first leg of 276B Roman 1, which is you have to be in the UK for 10 years lawful residence, and you
Yes.
haven't accumulated that.
Yes.
Now, our reliance is upon part 5, Roman 5, which is that you have an exception to this rule, which is if you put in an application within 14 days, even though 3C leave does not continue, there is some sort of leave, you can say, or at least you have a right to stay in the UK, and based on that right, if you finish your 10 years, then this is an exception within immigration rules, and you should be allowed indefinite leave to remain. This decision has kind of settled that settled the score when it comes to this point, isn't
Yes,
it?
yes. I mean,
Problem is it cannot go further. It's a permission decision for
Yes.
Court of Appeal, which is very surprising because panel of judges, they specifically instructed a reported committee to report that decision, which is generally not the case.
yes.
What's your comments on?
Well, you're right about the legal point that there is again a lot of confusion. People believe that just because they made an application within 14 days, they have 3C. And that's why I find myself both trying to explain to lawyers, but for some reason also with clients, that there's definitely no 3C. And whether the clients would understand this point or not, what they believe is that if you made an application, it is considered an in-time application because there is this 14-day period. But what people need to understand is a 14-day period which allows you to put in an application which would be successful, yes, if you make a tier 1 application, if you make a tier 4 application, because those applications do not require you to have completed 10 years. They're just simply checking the other requirements, and then they see that yes, you made an application within 14 days, so you were not an overstayer. But the problem is that when you make an application under paragraph 276, then there is a specific requirement, as Oves clearly said, which is the first leg of the immigration rule, that you must have completed a full period of 10 years. And you cannot rely on the fact that you made an application 3 months early, but within 14 days, because it's not an in-time application and there's no 3C. So all you really rely on is upon the separate concession or the separate immigration rule, which says that if you make an application within 14 days, the period of overstaying will be disregarded. So we say that there is some tension between these two rules, and of course without specific clarity, which perhaps the case of Qazi or the case of Ahmed intends to give, there is still a problem with the rules themselves, and the court's interpretation may well be there, but we believe it's still not been properly explored. That if an application is being made within 14 days, then as Oves said, leg 5, it should be in presumption or should be in favor of applicants. And therefore that period should be recognized as a somewhat form of lawful residence, because the Home Office can't, as per their own policy guidance, remove that person. And if his residence was lawful, then that should mean that it goes towards his lawful 10 years residence, and the application should be decided in their favor. Of course, we never say that if the Home Office decides the application quicker, when the applicant has only been here 9 years, 10 months, then we're not arguing anything. But what we say is if the Home Office has been sitting on an application which has not been decided, made within 14 days, and the applicant is now accrued 10 years, there should be a right of appeal, and they should, well, if it's refused, there should be a right of appeal, but it should not be refused and the applicant should be successful. So I think that's
our position.
That's our position, and we have to see how this goes. But the variation, I think, is a problem because there is case law on this. It's my own case that we're working on some time back, which it basically means you can only vary an in-time application. You can only vary an application when you have 3C leave. But if you don't have 3C leave, there is no leave to vary. So what is it that you're varying? So what sometimes I've seen, which is of course in defense of clients something that they have to do, is that they've been here for less than 10 years. They would submit application A and later vary to application B. The Home Office has always looked at it differently, but I believe the case of Qureshi says that the date of application becomes the date of the last application that you made, which would mean that there would of course be then a gap of quite some period. But what's your experience with these variation applications? How's the Home Office looking at them when someone's not completed 10 years and they make a series of applications and take them to 10 years?
I think after your reported case on this matter, Home Office has now changed their guidance and they have clarified by giving certain examples in their guidance. So what they tend to do now is if you don't have leave to remain, put in an application and you vary that application with another application, their guidance states that it's the date of the first application which will be considered if you have varied it with the same application, same type of application.
Okay. Is that for the assessment of the evidence or purely that the date of application will be the date of the first variation?
Well, it specifically states that if, let's say, you have varied a human rights application with point-based system application, the assessment of evidence is the date of the application. Yes. But the date of application itself will be considered the original application.
Which is very helpful.
Which is very helpful. And we recently had a case and we used this guidance and we discussed it, if you remember. Yes. And we were successful. Home Office accepted that and they've granted tier 1 extension to our client.
Well, it's the same story really. I had a client who had an issue with his maintenance requirements when he was making a second application. Visa had expired. So we made a human rights application, arguing obviously that it's a near miss. It's the only requirement is missing. There was a problem, a genuine issue because of which he had to withdraw funds, and he started his 90-day period again. Once he completed 3 months, we varied the application. So again, I'm cautious of using the word vary because there was no 3C leave. But when we made a second application, which is tier 1 application, we in our cover letter explained to the Home Office that the date of application should remain the date of the first application. So our client should not be considered an overstay, but we're giving you maintenance now with respect to post 90 days. They approved the application, but I wonder though whether it was just an individual decision by a caseworker, because I haven't seen any case where the courts have properly grappled with this issue and confirmed what we're saying is right. But it's good for us, of course. So far, it helps us. So I guess the point here really is, it's a fine little point, but if there are applicants out there who face difficulties in relation to maintenance requirements in the PBS applications and they need a short period, some applicants believe that, or lawyers would believe there's no solution. There is a solution within the policy guidances. Come and see us, we can talk about this more.
Excellent. Thank you, Shreya. I also want to discuss, we're all aware of 3225. We've discussed this issue with general applicants quite a lot of times on this program as well. Now that we have Balaji Gari, Home Office has recently obtained stay from the court until 17th of July, which is gone past. But they still haven't come up with a policy as to what they want to do with these type of cases.
Yes.
One of the suggestions we're hearing is the same as we had in your reported case of Asan and others, Surinder Kaur, correct? Harvinder Kaur, sorry. So that you invite the applicants to serve Section 120 notice, invite them to make a human rights claim, but consider the date of human rights claim on the date it was made.
Yes.
So basically they can't claim 10 years long residence, so they would maintain their decision, but they would ask them to make further human rights claim, accordingly grant right of appeal or no right of appeal or certification. This is something I think which will be challenged. I don't know what's your take on that, because technically they should put applicants back in the same situation they were before 3225 was applied to their case.
Yes.
Any recent updates you are aware of regarding these matters?
I believe the new policy will be, again, as you said, very close to what they did with the case of Asan. what they've literally said is that yes, if there was a human rights claim before us and we haven't dealt with it, then yes, or if the applicant at that point made under section 120 or in any way made a human rights claim to the Home Office, we'll give them a right of appeal. So they can provide their innocent explanation as to what's happened. So this determination's kind of similar to what was said in the case of Essen. And what I believe the new policy will simply say is that if there was an implied or a very strong human rights claim as part of the PBS application for settlement, then we will give you an opportunity now to either provide that innocent explanation and or we give you a right of appeal. Because curiously what's happened, at least in most cases, is that there was an interview or there was a questionnaire sent out to applicants. And what the Home Office, I believe, will say, or they even said in this case, is that we did give an opportunity here. But the connection with the human rights cases or the human rights point is again very strong in this determination. And what it appears to be the case is that at least I'm arguing with the government legal department on one of my cases where what I simply said is that you refuse the application, the settlement application with respect to 5 years unlawfully. And as per Balaji Gari, you should have given him a right of appeal. My client, meanwhile, had made a separate human rights application, which was pending. So what they said is that no, it wasn't incumbent upon us to consider his human rights at that point, and in any event, he's made a separate human rights claim now. So this becomes two issues. But with respect to the first issue, what I say is that because the applicant had been in the country for about 9 years, had 2 children, there was a strong implied human rights claim, and that's why he should have been given a right of appeal as per Balaji Gari. But what I believe is going to be the problem is that they will say this issue is now academic because a new human rights claim has been submitted. So in summary, what we say is that we still have to see what the new policy will be. I agree with Oais that it shouldn't really be a question of saying that whether you made a human rights claim, whether you can make it now. It should be that those decisions were unlawful. They have to be reset, and applicants again need to be properly called for an interview, be provided an opportunity, a platform to provide full evidence of why there were tax amendments or how the income was genuine. Everything needs to be looked upon fresh, which is really the best interest of applicants.
I mean, as I vaguely remember the case, another issue which was raised in that case was that even the Home Office sent questionnaires to the applicants, after receiving the replies, they did not go back and inquire based on the answers provided by the applicants. So they weren't given opportunities to explain their answers, not just their situation, but their answers as well. So
yes.
And they Home Office took a position based on their own assumptions and then refused the applicants. So this was another issue that was raised in that case. So hopefully,
the courts were not too happy with what happened to the question.
Yes, procedurally, they were very much criticized in this matter.
And I guess that's always been the problem, whether it's a TOEIC issue or whether it's this issue, that they just sadly we accept that it's a government department, but they could do things properly. Back in the day with tier 1 applicants, with tier 1 entrepreneurs, which they've now shut because allegedly there's abuse without any evidence of what the abuse is, why can't you counter that abuse. Applicants were being called in for an interview, and there was a delay of 11 months, 13 months in considering these tier 1 entrepreneur applications. But eventually when we got the decisions, although the applicants had been interviewed 2 hours or 3 hours, there seemed to be no reference to the interviews. If there was reference, they would pick up 4 or 5 questions which they were not happy with. And they would forget, same as marriage interviews, that how long was the interview. What I believe is that whenever they have a problem with genuineness, there should be something very subjective. Just maybe like a marriage interview, call them in, interview them properly, whether it's on the business, whether it's on tax amendments, because it's simply not sufficient. I've seen a case where there's been a tax amendment, but in spite of the tax amendment, the person's income was still above the required level. About £40,000. So it's absolutely ridiculous to refuse that application just because there's a tax amendment, because it makes no difference to the Home Office. The income requirement was still above. But what happens is they just apply a blanket approach. They see an amendment, they're not interested in your story. Another client who had his shop burned down in the riots of 2016. So it's such an exceptional factor. Lost all his tax returns, just submitted it with what information he had. HMRC doesn't prosecute or doesn't do anything, which again the Home Office says that I believe that's what they argued at Balaji Gari. But I think what the criticism constructive criticism to the Home Office is there has to be a subjective interview, listen to their story, verify their story from the accountants. If the accountant is saying that, it was my mistake, why won't you accept that? It's a professional, regulated professional, but that's sadly how things are. But the good news, of course, so that's all, of course, maybe bleak news, but our new Prime Minister has re-endorsed his view, which he held when he was a mayor, and that's that he will do something. Of course, this was as a consequence of a question that he was asked during question time, not something that he, brought down as part of his portfolio, that these are the things I'm going to do. And he had to defend something that he said before, which is why I'm slightly cautious whether he was just simply saying that, yes, I'll stay consistent with what I've said. But the good news is that the PM has confirmed that he will be looking into regularizing people who are in the country, because, of course, it's no benefit if people are being forced to work cash in hand, and they can be brought into the system and they can be properly taxed. It's good for HMRC, it's good for the pension department, it's good for everyone. And I believe if the PM goes ahead and announces such a policy, it would be really good for so many people who are in the country without any form of leave, or people who are unfortunately in the leave or in the country, but then they've fallen to these restrictions of not being here properly 10 years, but they've been taxpayers. There should be some form of amnesty, and it looks like something's coming. Of course, if something happens, we will update you. Everyone out there would update you.
Excellent. Thank you very much, Sharia. Another question we receive regularly is regarding Tier 1 extension, whether it's accelerated route or
Yes.
General extension. The scenario would be that if someone has invested, let's say £200,000 in a company, in an existing business, but there are other investments in that business as well. Overall job creation could be in general extension 3 or 4, or for accelerated route, for example, 10 or more. But can they claim all the job creation from that business, net creation only I'm talking about, so not the previous employments, or they can only claim as per the percentage they have invested in the business? So for example, if a business has taken external investments of £1 million, and there are 10 investors, so £200,000 each per investor, job creation is 10 or 9 in that case scenario. Can every single investor claim that those 9 jobs, or will have to be as per the percentage, which is in this case 20%, I guess?
I understand. It's a fair and a complex question, but I think the Home Office have left this point to applicants and their accountants. So what needs to be shown is that as a consequence of your investment of £200,000 or £50,000, which relevant route you are in, as a consequence of your investment, there has been an increase in the net jobs that have been created by the company. So if the company employed 4 employees before, this new director comes along, invests £200,000, as long as you can show that his investment resulted in the creation of the 2 or 3 or 4 or however many jobs, then you would satisfy the requirements. I haven't seen the Home Office raise a specific concern in such an application. One case that I did where they could have possibly asked this question, unfortunately, there was also a net increase in the turnover of £5 million. It was a recruitment company, so there had been many directors before. This person comes in and invests £200,000, a bit more than that. So it was a fair question for the Home Office to ask that there's so many directors, such a big business, how are you claiming that simply all the new 4 or 5 jobs or 10 jobs in that case are coming out of the consequence of this person's investment? Of course, it could be justified. You could simply say that there's a particular project and all the new employees have been hired as a consequence of this 200k. It can be said it's enough amount really to cover 10 jobs. So I would say it's for applicants and their accountants to say that yes, this happened. If this happened, the Home Office can't really say, no, hold on, we're going to only apportion it as per your percentage. Is that what your research says as well?
Yes, that actually brings us to the point we discussed previously. If it's a direct result of that investment of £200,000, then obviously you have satisfied the requirements. But if it's not the direct result of those £200,000 and it's a result of other investment that's come in during the same period, then of course, in my opinion, there will be some trouble satisfying that requirement.
Yes. I mean, that's why I think they have two things which you are required to submit additionally. So if you've taken over an existing business, of course, for applicants following up this topic for the first time, if you've come here into the UK on the tier 1 entrepreneur route and you're investing in an existing business, one thing you need to be sure of is that you can't claim points for the jobs which previously existed. The company needs to create a minimum of 2 more jobs. And what additional evidence you would need in support is a letter from an accountant which confirms this. And what you would also need is that you would need to submit the previous year's real-time tax information from the HMRC, so the Home Office could compare the previous tax year, or at least from the point that you joined, and the new one, so they could see that yes, as per HMRC information as well, there were no jobs which existed, or there were lesser jobs which existed after your investment. So it's a complex route where you rely on accelerated route, or if you've invested in an existing business, because there are other restrictions such as what is the investment that's gone towards goodwill, existing stocks and fixtures. So again, don't take it simply if you're investing in an existing business. It's possible. Don't be discouraged. Speak to specialist immigration lawyers from before. Accountants themselves may advise you with something which is completely lawful as per the local HMRC laws, but there are tensions between what the HMRC wants and what the Home Office wants. Best to take advice from day one. So that's really the tier 1s.
Excellent. Okay. And another problem we face, or a lot of refusals we have on tier 1 extension, is when people have simply bought a running business. So they simply, let's say, for example, they're buying a chicken shop or any other running business. They would pay to the previous owner. They will buy it for £200,000 or more, and they say we've invested money.
Yeah, that's a big problem, isn't it?
Yeah.
I mean, I had a client who I unfortunately met, unfortunately, three months before his visa was expiring, running a big shop in Southall, had purchased it from someone for £200,000 plus. The whole amount went to goodwill and the existing stock and trade. One would think existing stock should at least be covered, but it's not. So within those 3 months, the applicant had to invest a further £200,000 because the rest of the money just wasn't satisfying the requirements. So you see, with this problem, with day 1, if the client had properly been advised, he could have been told that the payments that you would pay towards your future stock and trade, for your license, for your rent, all of that could be counted as investment. So maybe whatever you're buying the shop for, it has to be paid for, but the investment can be recognized if you structure the investment properly, not simply just run it from day 1. So yeah, specifically, I guess what Wes and I are saying is that if you're investing in an existing business, there are possibilities. Speak to immigration lawyers who can tell you that what will work. Don't leave it to the last 2 or 3 months, because then you will be told you need to invest more money, and maybe the job creation requirement will be a problem.
Thank you. Our next topic, sole representative. We have covered this topic before as well.
Yes.
There are a few confusions amongst the inquiries, people inquiring on this topic we receive. One of them is that you have to have a degree from a country you are applying. So a bachelor's degree or a specific high level of English language proficiency as compared to tier 2 migrants.
Yes.
This is not the case. So if you can just briefly explain that category.
No, absolutely. I mean, it's been a category which has been along for a long time. It's always been ignored because they were focused on the points-based application, specifically on the tier 1 and the HSMP. But this is an ancient rule. The full name of the category is the representative of an overseas organization. So essentially, the idea is that you're coming to the UK to open a branch office, a representative office of a business which exists abroad. That business is not moving its head offices and headquarters to the UK. It's going to be a branch office, a small office, and the head office will remain abroad. You must be at a senior level within that company abroad. Because the Home Office expects that if you're coming here to open a branch office, that you must be in a position to take day-to-day decisions, managerial decisions.
So, is there a definition of what the senior position is under the regulations?
My understanding of that is that no, they haven't specifically said that you must be a director or a senior, but I believe the word senior manager is there somewhere in the guidance, unless you've seen something. But I think the thought process behind the title is that you must be in a position to take day-to-day decisions.
Okay.
That's what they expect. So coming back to that point is that yes, of course, you must be employed abroad, and then you're being sent to the UK to open a branch office. So one thing you need to be so that's that. Just first addressing Oasis' question, there isn't a requirement that you must have a certain level of education. There isn't a requirement that you must be speaking a high level of English. There is a requirement. There is an English language requirement at level B1, I believe, or A1. Yeah. So that's a lower requirement of 2.5 in IELTS, right? Yeah. So it's a very low level, 2.5 in IELTS if you want to compare. So comparatively, you will see that Tier 1 had a requirement of B1, which is 4.0 in IELTS. This one has...
We started with C1, Tier 1. So if you
yes.
remember.
That was like 7.0, which was impossible to meet. Then they lowered it down. So the English language requirement is a very easy one. There's no degree requirement. So all said and done is that you're working for a company abroad, you know all about it, and you want to come here and open a branch office. I've done it as a very popular scheme for people from, let's say, in the textile industries abroad, because they're exporting a lot of stuff to the UK and they want a branch office here to really come here and expand their business. So beyond all of this, I've seen two confusions. One, applicants decide that yes, I've got a business, I'm going to send myself to open a branch office. You can't do that. If you're the owner of the business, if you're working for yourself, that's the problem. The Home Office is saying that the focus, the center, the head office cannot shift. And similarly, that's why they say you must not have a majority shareholding in the company, because then you've just decided as a bias that you're going to send yourself to the UK to do this. That's not allowed. So yes, we would say even if you're up until 49%, as far as the rules concerned, you don't have majority shareholding, so you can come. But safe percentages that I've worked with is 20, 25, 30, 35%. You're not a majority stakeholder. You do have some say in the decision making, but the company has, or the board has decided to send you to open a branch office. One more thing you need to be careful of is that the company should not already have a presence here in some. So if you're representing a brand, or if you're working for a brand in Pakistan or India, for example, and then you're coming here to open a branch office, but that brand itself, let's say, has a presence here. Let's say you're in sports goods and selling Nike products in abroad anywhere, and then you say I'm going to open a branch office here, but the product you're selling is a product which is already present here. You have a problem. So this is something fine which not a lot of people would be aware of, because you wouldn't have done these cases before, and you're making these applications more popularly now because the Tier 1's closed. But the Home Office actually looks at this point as well, whether the brand itself has a presence in the UK, and then they'll say you're not going to be the sole representative of Nike, because you've got Foot Locker, you've got JD Sports, you've got half the world selling that. So those are the things you need to look at. So although there is a lot of marketing now on this specific route, I believe some of the marketing is not responsible marketing. Just as we see in innovator and startup, people are saying good days, Tier 1's closed, and now the requirement is not 200, the requirement is 50k. It's absolutely wrong. That's not the case. Speak to professional lawyers. Ideally speak to lawyers in the UK, because at least they are regulated. If you're speaking to lawyers out in Dubai, India, Pakistan, unfortunately, a lot of these jurisdictions don't have any regulations. So if you've been advised wrongly, you can't do anything about it. So although there's that problem of instructing a lawyer in the UK, you can't shake his hand, but in this time and age, beyond that, it's more important to have the proper advice.
Mm-hmm.
Yeah.
Thank you.
So that covers sole rep, doesn't it? I didn't miss anything.
Now, just to clarify one point, I probably need your clarification on that. If someone wants to open a branch of a departmental store who sells different brands,
yes.
Example, Harrods,
Yes.
Let's say we had Harrods not in the UK but in Dubai, and they want to open a branch, and all they sell is different brands. They don't have their own brand, for example.
Yes.
Would that be qualified?
I believe that would work, because then within itself, there is that brand which sells all of these products.
Mm-hmm.
So I definitely think a brand like established brand like Selfridges or Harrods, or if you are in retail business, Carrefour in Dubai, I don't see a problem how they can be prevented from opening a branch office here. Yeah,
Okay.
but I do think that the Home Office's thought process behind this category is that you're furthering the interest of that business which is abroad. And so you're representing them, the manufacturing is not moving, and all of that's still going to happen abroad. So the textile industry is a classic and best example that you're not going to ever going to be manufacturing the product here. You're simply going to be in a better position to negotiate with all your buyers in the UK and or in Europe.
Excellent, thank you. And anything specific you want to discuss? Because I wanted to move on to human rights.
No, I think we've covered the sole rep
yeah.
and accelerated, and I'll let you take the lead, really.
Sure. Article 8 matters. A lot of people have confusion. What exactly is Article 8? So it's your private and family life in the UK. What exactly does that cover? So if you can clarify in a nutshell.
Well, as a starting point, what a human rights claim, according to Home Office, is that if you've already either accrued 20 years of residence in the UK, lawful, unlawful, doesn't matter, then that amounts to a human rights claim. Similarly, if you've been here lawfully for 10 years, then again that amounts to a human rights claim.
Under Article 8.
Under Article 8, specifically. Well, now they've designed specific immigration rules for this as well, which cater for this. But when we say, I guess it's important from a client's perspective to understand that, have I got a human rights claim?
Mm-hmm.
So yes, I mean, by definition, if you look at the ECHR, then of course you have a right to a private and family life. So one would argue that if you've only been in the country for 4 years or 5 years, you have a private and family life. You have a private life, certainly, but the Home Office says that a period of private life that they would recognize is 10 years or 20 years, which would either then give you a visa, or if there are any problems within that, they give you a right of appeal. But then we also see, again, there is an immigration rule which caters to this, but if you have children who've been here 7 years, then that amounts to a human rights claim as well. So that would also, again, either result in a grant of leave for you or your children, and or give you a right of appeal. So that's in summary, beyond leaving aside the other complex categories of whether you made a protection claim or asylum claim, which are more related to Article 3 and other immigration, other ECHR regulations. An Article 8 claim is specifically, as the words say, a right to a private and family life. So if you've got a strong private life, which could mean beyond period of residence, that if you're doing something which you would no longer be able to do in your own country of residence, you could argue that your private life would be infringed in this way. There's the half-life rule, that if you spend more than half of your life in the country, you came here when you're 10, you're 21 years old now, so you could argue that you spent more than half your life here, again goes towards your human rights. So there is a whole list of what is a human rights claim as defined by the Home Office, but these are your Article 8 cases, aren't they? I think the generally popular ones.
Yes, another very hidden provision under the immigration rules is that if you have lived here for less than 20 years and you have no links to your country of origin, this is something that is Home Office looks at it in a way that, for example, someone's holding a Pakistani passport, for example, but lives in Saudi for, let's say, 8, 9, 10, 15, 20 years, and before they come to the UK, they have never lived in the country of their origin. They've always lived outside. How have you come across these cases? How does Home Office look at these type of applicants?
Interestingly, yes. I mean, I did a case recently, an appeal recently, connected or not to connected, not specifically to what you said, but the judge placed a lot of weight on the fact that the applicant had much lesser ties to his country of origin, because before coming to the UK, these are dependent parents, before coming to the UK, they had lived in the UAE for about 7 to 8 years, and then they had further accrued more residence in the UK. So overall, what the judge said is that because one of the dependent children had been in the country for about 7 or 8 years only in Pakistan, and beyond that they spent time in Saudi and now in the UK, the period of residence had to be given more weight as opposed to someone who had effectively stronger ties. But because it was a combined family application and there was an issue with one dependent, the judge was also adding to the assessment that here parents and the younger child had been here for 7 years. But I agree with you that yes, there will be more weight for applicants who have had overall less period of residence in their country of origin. But is there a specific immigration rule which caters to that? Is that what you were saying?
Yes.
Okay.
Yes.
Okay.
Again, we can discuss that in the next episode in more detail.
Sure.
There's a lot of inquiries regarding that matter as well. So
Sure.
we'll probably have to look
Yeah, I
into
suppose
it.
so. Then we could, in our next program, talk about the half-life rule,
Yeah.
talk about how the Home Office is looking at the fact that you spent less time in your country of origin where you will be sent back to, and you've been out and abroad in other countries.
Awesome. I think this is all for today. We've covered everything. Is there anything else you want to?
No, just I wanted to ask viewers that it's always helpful if you could send us emails in the 2 weeks before we reappear as to what is the problem, what is the confusion, so we could then sort of decide on what topics to focus on. So we could, well, of course, the purpose of these programs is just to help viewers talk about issues which are prevalent or an updates. It's always helpful if you send us emails in advance to say, I'm confused about this situation, talk about it, or contact me, so then we could give you tailored advice.
Yes, and also, it also helps us improving this program as well as to what exactly viewers want to know. Because immigration is always changing, so case laws, UK is a common law based jurisdiction, so case laws are coming in. We're here to help. So if you have any questions, just email us directly, email Sharia, me, or our team, and we're happy to help. We're also starting a series of small videos for you covering different topics under immigration, family law, personal injury, litigation. So if you have any specific questions you want answered or any specific topics you want us to cover, please feel free to email us. And most of you already know that we always try to keep you updated on our Facebook page, on our website. So if you can go and like our Facebook page, you will get updates from us as soon as there is any. And keep reading articles we post on our website. It's always helpful. Leave your feedback, email us directly, leave your comments. So it always helps us knowing what exactly do you think of the services we provide. And with that, we thank you all for listening and hearing, and hopefully we will come back with some new answers to your questions in 2 weeks time.
Definitely. Take care.
Thank you.